Thank you for responding to our invitation upon a very short notice. This evening, I am privileged to have been nominated by the party to address you on this all-important matter that borders on our constitution. One of our own, Kwame Bafo Abronye, has been arrested, remanded by a court, which is supposed to be a court of justice under normal circumstances. The party considers this a constitutional outrage. The arrest itself, the so-called prosecution, and the remand. But before I set in motion the submission of the party expressing its view on this disturbing matter, let me refer to the 2015-2016 One Supreme Court of Ghana Law Report, specifically at page 175 in the matter of Martin Kpegu number 2 versus the Attorney General number 2 in writ number J1/13/2025. This reported case was delivered on 5th May 2016. I shall rely on the general view of the courts in their declaration. Quote, Article 19C of the 1992 Constitution has given a suspect under investigation or an accused on trial the benefit that he was innocent until the court had found him guilty after a hearing or following a plea of guilty. The grant of bail was one of the tools available to the court to ensure that a suspect or an accused, as the case might be, was guaranteed his innocence until the court had found him guilty. The presumption of innocence in terms of Article 19(2)(c) of the Constitution embodied freedom from arbitrary detention and also served as a safeguard against punishment before conviction. It also served as a preventive measure against the state from successfully employing its vast resources to cause greater damage to a person who has not been convicted than he could inflict on the community. Therefore, any legislation outside that said so, that would be clearly contrary to the letter and spirit of Article 19(2)(c), which has guaranteed his innocence until otherwise declared by a court of competent jurisdiction. End quote. And specifically, my Lord Doche, JSC, who was part of the majority at page 176 of the law report, said in these veritable words, which I quote, Article 19(2)(c) of the Constitution takes precedence in the laws of Ghana, and any law found to be inconsistent to this constitutional provision must, on the basis of Article 2(1)(a) and 131(b) of the Constitution of 1992, give way and be declared inconsistent and in contravention of the Constitution 1992. In my opinion, Section 96(7) of Act 30 as amended is one such legislation that is inconsistent with the Constitution. The general tenor of Section 96 of Act 30, which deals with grant of bail in general, therefore gives very clear indications. On the whole, the courts have a discretion to grant bail to persons appearing before them in criminal cases upon conditions stated therein. The ousting of grant of bail in section 96(7) is therefore odd and unnecessary interference with the discretion of the court. The lead judgment of the court delivered by my brother Benin JSC, striking down 96(7) of Act 30 as amended as unconstitutional, in which I concur, is not a carte blanche for the court to admit every Tom, Dick, and Harry to bail pending trial, because the removal of the statutory shackles in the impugned section 96(7) of Criminal Code Offences Act 1960, Act 30. On the strength of these, I set in motion the concerns of the party in respect of the remand of Kwame Bafo-Abronye, our Bono Regional Chairman. Ladies and gentlemen, this evening, the party is here deeply troubled by what is happening in our country. What has been done to Mr. Kwame Bafo-Abronye, also known as Abronye DC, our Bono Regional Chairman, is a profound constitutional wrong. It must be condemned without equivocation, without apology, and without delay. The arrest itself, the prosecution and remand of a citizen for words spoken in the public square is not justice, it is persecution. Now let me be honest about where the party stands. The party does not condone irresponsible speech. We never do, and we never will. Public discourse carries responsibility, and we believe deeply in that. Where speech genuinely damages a person's reputation, Ghanaian law already provides a remedy, a civil remedy, measured, proportionate, and designated precisely for that purpose. It's been designed to achieve one aim: to allow a person who is injured to resort to civil reliefs. But what Ghanaian law does not provide, and what it was never designed to provide, is the conversion of a civil grievance, assuming without admitting that one even exists in this case, into a criminal prosecution. It does not authorize the marching of a man before a circuit court, the stripping of his liberty, and his consignment to state intelligence facility. That is not justice. That is the iron fist of state power wearing a legal glove. On the 13th of May 2026, Mr. Abronye was arraigned before Circuit Court 9 here in Accra. He faces 2 counts. First, offensive conduct conducive to breach of the peace under Section 2071 of the Criminal Offences Act 1960. Second, publication of false news under Section 2081 of the same statute. And what is the foundation of these charges? A social media video in which Mr. Abronye criticized a circuit court judge. He questioned that judge's impartiality. He questioned the conduct in the discharge of the public duty as provided for in the judge's judicial function. That is the sum total of his alleged crime. He spoke. He criticized a public officer. By the way, since when did criticizing a judge become a criminal offense in Ghana? Section 2071 requires conduct that is likely to occasion a breach of the peace. Political criticism of a public official, however sharp, does not meet that threshold. It is protected expression under Article 21(1)(a) of the 1992 Constitution. And the false news charge? A man expressing a political opinion about judicial conduct is not publishing false news, not by any honest reading of that provision. This prosecution of Abronye is built on sand, and we, the party, will watch it fall. the bail denial. A judge who forgot his oath. By the way, that was not his first. Let me turn to what happened in that courtroom. It demands its own separate and pointed rebuke. Counsel for Mr. Abronye presented a bail application. He argued on solid grounds. The charges, as we all know, are misdemeanors. The accused, as it was made known to the court, has a fixed place of abode. He is a known public figure with reliable sureties. His health and family responsibilities were placed before the court. The prosecution opposed bail on one ground only, that Mr. Abronye, if released, was likely to commit similar offenses. I repeat, according to the prosecution, in opposing the bail application, it said that if Mr. Abronye is released, he was likely to commit similar offenses. In other words, the state asked the court to imprison a man before any findings of guilt because he might speak again. His offense was speaking. And surprisingly, a court agreed. A citizen was therefore imprisoned, not for what he did, but for what he might say. That is not law. That is censorship from the bench. That reasoning is a constitutional disgrace. It is irreconcilable with Article 14 and 19 of the 1992 Constitution, which guarantee personal liberty and the presumption of innocence. A judge who denies bail because an accused may continue to express political opinions has not administered justice. I say what I'm about to say as a practicing lawyer, as someone who has spent his professional life in courtrooms, who has profound respect for our judiciary and deep admiration for those who carry the weight of dispensing justice. I say this not in anger, but in fidelity to the Constitution I have sworn to uphold, and with all the candor, humility, and respect I can command. When a court denies bail not to serve justice, but to serve silence, it has administered political censorship from the bench, and that, with the greatest respect, is a betrayal of every principle that gives judicial office its authority, its dignity, and its legitimacy. Now, let me specifically deal with the nature of the remand. It was a BNI remand, and indeed, even so, there is a missing court order, no court order drawn. Every remaining doubt about the political character of this prosecution is removed by the decision to remand Mr. Abronye into BNI custody. The BNI, by law, is Ghana State Intelligence and Security Service. It is not a remand prison. It exists to address genuine threat to national security. Mr. Abronye posted a critical video about a judge. That is not a national security matter. It never was. This has nothing to do with the criminal justice and everything to do with political intimidation. But there is something even more alarming. I want every Ghanaian to hear this clearly. Even those who hate the guts of Abronye must at least listen to this matter. It has now been 4 days since the court pronounced the remand order. 4 days, as I understand it, on the basis of information available to the party at the time of this statement. Counsel moved up and down the courtroom, the registry, demanding for certified remand order. The court order, as at Friday, has still not been drawn. I therefore simply ask a simple question. On what legal basis did the Ghana Police Service take Abronye into custody and conveyed him to the BNI? On what legal basis did the BNI accept and held him. A remand order is not a verbal instruction. It is a formal judicial instrument. It is a written legal authority upon which the deprivation of a citizen's liberty must rest. Was a Ghanaian citizen delivered into intelligence custody or nothing more than a word of mouth? If so, that detention has no documented lawful foundation whatsoever. So I ask again, the Director General of BNI, did you receive any court order accompanying Abronye's detention? If so, can you provide a copy? If not, why did you accept him? And I ask my Lord, if my Lord thinks he is bold enough, why is he running away from his own court order? By the way, that Circuit Court 9 records are immediately tied. As you are making your submissions, the clerk is typing. So within 5 minutes after court, the records of court must be ready. Why has it taken days? And as at close of business Friday, the order was still not ready. What is the judge trying to tell us? Is he trying to change what he has said in open court? That Abronye should remain in custody until the case is finally determined, not even to the next agenda date. His language was clear. Is he running away from his own language? Is he afraid of public outrage against his own conduct? Article 14 of the 1992 Constitution requires